a $36 money order, a room full of laughing strangers, and one man who already knew something no one else in that building had bothered to find out. This is the story of how Earl Mabry bought 14 acres nobody wanted and made a development company beg. Harlan Pruitt does not panic often. He is the kind of man who irons his shirts twice and returns calls before noon. He has a corner office in a building his company owns outright. He has 3 assistants and a framed photo of a groundbreaking ceremony on the wall behind his desk. On a Tuesday morning in March of 2024, Harlan Pruitt is pacing. His lead engineer is on hold. His site foreman is on hold. His general contractor, who has already mobilized 2 crews and a grading machine, is parked at the edge of a field with nowhere to go. $112 million of development, roads, utilities, a planned community of 340 homes, is sitting completely still because of a 14-acre strip of land, because of one man named Earl Mabry. Pruitt's attorney calls at 8:47. She says 3 words before he cuts her off. We have a problem. He already knows. Go back 23 years. October 14th, 2001. Caldwell County tax auction. A gymnasium that smelled like old bleacher wax and burnt coffee. 8 folding tables arranged in 2 rows. A coffee pot in the corner that nobody had cleaned since August. 41 people in plastic chairs. The auctioneer had a laminated sheet and the voice of a man who had done this 300 times and stopped caring about number 200. Parcel after parcel moved fast. Farmland, gravel lots, a condemned house on River Street that drew 3 bids and sold for $900. The room had a rhythm. Raise a hand, sign a sheet, move on. Then the auctioneer read, Parcel 7-114, 14 acres, no utilities, no road access, back taxes owed, $31.40. A man in the 3rd row laughed out loud. That man was Harlan Pruitt. He was 38 years old. He had just purchased the 280-acre parcel directly adjacent to 7-114 on behalf of Meridian Land Partners, a development company out of Columbus, with 12 active projects and 3 more in contract. He was, by any reasonable measure, the most powerful person in that gymnasium. He leaned over to the man beside him and said something. The man beside him shook his head and grinned. 14 acres, landlocked, no road, no utilities, assessed value, $400. Nobody moved except Earl Mabry. Earl was 51 years old. He was sitting in the 2nd row in a canvas work coat with a torn left pocket. He had driven 40 minutes from his house on Cutter Road. He had a money order for $36 made out to the Caldwell County treasurer. He had owned it for 11 days. He raised his hand. The auctioneer pointed. Earl's hand came down. The room moved on. Pruitt did not look over. He did not need to. He had already forgotten the parcel existed. Earl walked to the registration table and signed the transfer sheet. The county clerk, a woman named Barb who had worked that table for 16 years, handed him a carbon copy receipt and a deed application. He folded both papers. He put them in his coat pocket. He poured himself a cup of coffee from the corner pot and drank it standing up. 4 locals near the door watched him walk out. One of them said something about the parcel. Another one said it wasn't worth the gas to drive out there. The 3rd one agreed. The 4th one had already stopped paying attention. Earl drove home. Dottie Mabry was at the kitchen table when he came in. She had a library book open in front of her and a cup of tea that had gone cold. She looked up. She did not ask how it went. Earl set his coat over the back of a chair. He said, "Got it," she said. "How much?" He said, $31.40. She picked up her tea. She took a sip. She did not say anything else. That was the thing about Dottie. She had been married to Earl for 27 years. She had learned that when he said he got something, he meant more than the thing itself. She did not ask what the more was. She went back to her book. Earl sat down at the table and took the folded papers out of his coat pocket. He smoothed the receipt flat against the wood. He looked at it for a long time. $31.40, 14 acres, parcel 7-114. To anyone else in that gymnasium, those 14 acres were a dead end. Landlocked land with no road and no utilities was worth less than the filing fee to register it. Pruitt had laughed for a reason. Most people in that room would have agreed with him. Most people had not spent 14 months in the Caldwell County Public Library reading Road Commission minutes from 1947 to 1974. Earl had. He knew something about Parcel 7114 that was not on the auction sheet. It was not in the deed description. It was not in the county's assessed value. It was sitting in a filing cabinet on the second floor of the county records building in a folder that had not been opened since 1973. He did not tell Dottie. He did not write it down that night. He just folded the receipt once, put it back in his coat pocket, and hung the coat on the hook by the door. Harlan Pruitt had a 280-acre development parcel and a company with 12 active projects. Earl Mabry had a $36 money order stub and one question nobody at that auction had thought to ask. The question was, why had a county that abandoned a road in 1969 kept filing tax records on the corridor for 4 more years? Nobody in that gymnasium had asked it. Earl already knew the answer. Before the story gets any heavier, hit subscribe, because what Earl finds in that county filing cabinet is the kind of thing they don't teach you in business school, and you'll want to see what it does to Harlan Pruitt. January 7th, 1999, second floor of the Caldwell County Public Library, one table by the window, a thermos of black coffee, and a yellow legal pad with nothing on it yet. Earl Mabry pulled the first microfiche reel from the drawer and fed it into the reader. He was not in a hurry. He had come because of a single item he spotted in a county commissioner's meeting summary from 1961. A line item in the infrastructure budget for a road extension called County Road 7 East. The line item was allocated. The road was never built. That kind of gap usually meant a cancellation, a rezoning, or a policy shift. Earl had seen 3 of those before, and none of them mattered. This one was different. It took him 4 visits to understand why. County Road 7 East was first platted in 1952. The survey was completed in 1953 by a state engineer named Hatcher. The corridor was 60 feet wide and ran a clean half-mile from the county road straight through the center of what would later be recorded as Parcel 7114. The Road Commission budgeted it 3 times between 1953 and 1967. Each time, the budget cycle closed without a groundbreaking. In April of 1969, the County Road Commission passed Resolution 44B, Formal Abandonment of the 7 East Corridor. Earl read it twice. He wrote on the legal pad, Abandoned, 1969. Resolution 44B. Then he pulled the next reel. The answer was on page 4 of a quarterly property tax summary from October 1973. One line, easy to miss, listed between a drainage easement and a utility pole setback. The entry read, Road Reserve, 7 East Corridor, filed by County Road Commission, assessed value, $0, owner of record, County of Caldwell, filed 4 years after abandonment. Earl set down the thermos. In property law, an abandonment is not the same as a conveyance. A road commission can walk away from a corridor and still leave the legal interest alive on the books if it never formally transferred the title to anyone. And if that same commission filed a tax record on the corridor in 1973, even at $0, even with no explanation, then the corridor had not been extinguished. It had been deferred. Earl wrote, tax record filed 1973, corridor not extinguished. He circled it. Then he went home for dinner. He spread a hand-drawn map on the kitchen table that same night. The map showed Parcel 70114 in the center. He had sketched the 60-foot corridor running through the middle of it from south to north, dead straight, connecting to the county road at the bottom edge. Dottie came in from the other room. She stood at the table and looked at the map. The kettle was on the stove. It had not boiled yet. She said, "Is that the Pruitt land?" Earl said, "Not yet." She said one more thing. She said, "When?" Earl said, "When they need it more than I do." The kettle went off. She turned back to the stove. He drove out to the parcel in February of 1999. The ground was frozen. He brought a compass and a photocopy of the 1953 Hatcher survey. He walked the 60-foot corridor from the county road to the northern boundary of the parcel. It took him 40 minutes. No structures inside the corridor. No fence lines at posts dated 1969. The land was clean. He drove out again in April. And in September, he started a notebook. A green spiral-bound one Dottie had left on the counter the previous Christmas, with no particular reason for giving it. He wrote the dates, the conditions, the coordinates from the survey. Page 1, February 14th, 1999. Corridor clear, no encroachments. Page 2, April 3rd, 1999. Tire tracks on eastern boundary, recent. Page 3, September 11th, 1999. Survey flags on adjacent parcel. New. The flags were meridians. He started tracking the adjacent parcel purchases in the county recorder's office that fall. Meridian Land Partners, an LLC registered in Delaware, had acquired the 80-acre Thatcher parcel in June of 1998, the 120-acre Conley parcel in November of 1998, the 80-acre Winslow parcel in March of 1999, and in September of 2000, they filed a letter of intent on the 280-acre Pruitt family holdings. Earl drew each acquisition on his kitchen map. He did it slowly, one parcel at a time, the same way you fill in a picture. When he drew the last one, he set down his pen. The map showed 560 acres assembled on all four sides of parcel 7-114. One developer, one project, one natural access point, the county road at the southern edge. And running from that county road straight through the center of 7-114 was a 60-foot corridor that the county had never legally given away. No road through that corridor meant no utility easement. No utility easement meant no permits. No permits meant 560 acres of development land was exactly as useful as the bottom of a lake. Earl closed the notebook. He looked at the map one more time. Then he put the map in the notebook and put the notebook on the shelf above the kitchen table where Dottie kept cookbooks nobody used. The trap was set. Now came the waiting. $4,000. The man on the front porch said it like it was supposed to end the conversation. He was young, mid-30s, pressed khakis and a clipboard, and a company truck parked in the gravel drive. He said his name was Garrett and that he represented a land acquisition firm out of Columbus. He said 14 acres with no road access was a difficult asset. He said he wanted to save Earl the trouble. He said $4,000 like a man who had never been told no. Earl was standing at the screen door with a coffee cup. He said, "No, thank you." Garrett said, "Mr. Mabry, you paid $31 for that parcel. This is more than 100 times your investment." Earl said, "I know what I paid." Garrett stood there for another moment. He was used to people who needed to think it over. He was not used to people who had already thought it over years before he knocked. Earl said, "Drive safe." He let the screen door close. That was 2004. Earl paid the annual tax bill on parcel 7-114 every spring, $11.20 per year. He mowed the corridor twice a year with a push mower, once in June, once in September. He kept the survey markers clear. He kept the boundary flags upright after every winter. Nobody watched him do this. Nobody cared. That was the point. The county called in 2009 a man named Assistant Administrator Fowler. He spoke in the careful way of a man who had been told to be careful. He said the county was reviewing historical road abandonment files. He said there might be a residual public interest in the 7 East Corridor. He said the county wanted to discuss a quiet title action. Earl listened to all of it. He asked one question. Is the 1973 tax record on the corridor still in the county archive? Fowler said he would have to check. Earl said, "Check and then call me back." Fowler did not call back. In 2011, a letter arrived by certified mail. It was from Meridian's legal department. Formal letterhead, 6 paragraphs. It referenced Resolution 44B from 1969. It cited the county abandonment. It suggested that Parcel 7-1114, being landlocked and without recorded access, might be subject to certain legal interpretations regarding adverse possession of the corridor. Earl read the letter at the kitchen table. Dottie was doing dishes. She did not ask what it said. He folded the letter back into its envelope. He put it in the green notebook between page 11 and page 12. He wrote on page 13, 2011. Meridian sent a letter. They know about the corridor. He underlined the last 4 words. The second offer came in 2014, not from an agent, from a county official named Harlan Pruitt, who had by then left the private sector and spent 2 years on the Caldwell County Planning Commission before returning to Meridian as regional director. He called on a Wednesday afternoon. He said the county and Meridian had entered a joint planning agreement. He said the project had significant economic value for the region. He said he was prepared to offer Earl $38,000 for the 14 acres. Earl said, "I appreciate the call." Pruitt said, "Mr. Mabry, there is no road to that land." Earl said, "There will be." A pause. Then Pruitt said he would follow up. He did not follow up. Dottie said that evening he called himself. Earl said, "Yes." She said, "That means he's worried." Earl said, "Yes." She went back to reading. She had understood it for years. Their daughter Claire was 12 in 2001, old enough to be at the kitchen table the night Earl first drew the map. She had asked him once the following summer why the strip of land had a line through the middle that wasn't a road. Earl had told her, "It's a corridor that used to matter. It's going to matter again." She had written that down in a school notebook. She did not know why. She kept the notebook. In 2019, Meridian's own lawyer came to the house. Three-piece suit, leather briefcase. He introduced himself as Ronald Fisk. He sat at the kitchen table. Earl poured him a coffee. Fisk opened his briefcase and removed a single sheet of paper with a number on it. $114,000 for 14 acres that had cost $31.40 at auction. Earl looked at the number. He did not touch the paper. He said, "I'm not interested in selling." Fisk said, "Mr. Mabry, with respect, this parcel has no road access. The corridor was abandoned in 1969. Without legal access, this land cannot be developed, cannot be permitted, and cannot be used as leverage in any legal proceeding. Our title attorneys have reviewed the record." Earl said, "All of it?" Fisk said, "Every filing." Earl said, "Then you know about the 1973 tax record." Fisk was quiet for 3 seconds. He said, "That record is a clerical anomaly. It doesn't constitute a legal interest." Earl said, "That's one interpretation." Fisk closed the briefcase. He said he would be in touch. He left the coffee on the table. In Meridian's Columbus office that fall, a project manager sent a memo to Pruitt. The memo said the 7 East Corridor title question had not been resolved. It said the company's permit applications for the Caldwell project were stalled at the county planning office. It said the situation required escalation. Pruitt read the memo. He called his lead attorney. The attorney said they needed to pursue the abandonment claim formally or write off the project entirely. The project represented $118 million. Pruitt said, "File the claim." Earl's phone rang on a quiet morning in February of 2024. Unknown number. He picked up his coffee cup. He set it down. He picked up the phone. Ronald Fisk spoke first. He said, "Mr. Mabry, Meridian is prepared to make a final offer. $190,000, all cash. 30-day close." Earl said, "No." Fisk said, "Mr. Mabry." Earl said, "I'll have my daughter call you back." He hung up. Claire Mabry drove down that Saturday. She was 41 years old. She had passed the Ohio bar in 2008. She had spent the last 6 years doing property and easement law for a firm in Columbus, which meant she had spent 6 years reading exactly the kind of documents sitting in her father's green notebook. She spread everything on the kitchen table. The original deed, the 1953 Hatcher survey, the 1969 abandonment resolution, the 1973 tax record, the certified letter from 2011, Fisk's business card from 2019, and the notebook. Every page, in order, 23 years of entries in Earl's handwriting. She read in silence for 40 minutes. Dottie set a pot of tea on the counter. She did not interrupt. Claire looked up from page 9. She said, "Dad, did they ever record a formal conveyance of the corridor?" Earl said no. She said, "And the county taxed it in 1973. Earl said, "Page 9. She turned back to page 9. She read it again. Then she said one word, "Good." She called Fisk on Monday morning. She identified herself. She said her father was declining the offer and that they should expect a formal response to Meridian's abandonment claim, which had been filed in Caldwell County Circuit Court the previous November. Fisk said Meridian's position was supported by 35 years of legal precedent on abandoned road corridors. Claire said, "We'll need to verify that against the 1973 filing." Fisk said the 1973 filing was a clerical anomaly with no legal weight. Claire said, "I'm glad you have that position in writing." She hung up. The hearing was March 19, 2024, Caldwell County Circuit Court. One judge. A small room with fluorescent lighting and a table that needed refinishing. Meridian's legal team brought 4 attorneys, a title expert, and a bound brief that was 62 pages long. They cited Resolution 44B. They cited 37 years of passive use. They cited 4 precedent cases from Ohio appellate courts. Claire brought 3 documents. She set them on the table in a single stack. The first, the 1953 Hatcher survey, showing the 60-foot corridor running through the center of parcel 7114. The second, Resolution 44B from April 1969, the abandonment, Meridian's own exhibit. The third, the 1973 tax filing, Road Reserve 7 East Corridor, filed by County of Caldwell, assessed $0. She said the corridor was abandoned procedurally in 1969, but the county filed a tax record on it in 1973 without ever recording a conveyance to any private party. Under Ohio property law, a taxed interest that was never conveyed is a deferred interest, not an extinguished one. Meridian cannot claim adverse possession of a corridor they cannot prove was ever legally transferred out of county ownership. My client holds the only recorded deed on the parcel the corridor runs through. One of Meridian's attorneys started to speak. The judge held up a hand. He looked at the 3 documents for 90 seconds. He ruled for Mabry. Meridian's lead attorney reached for his phone before the judge finished the sentence. The call from Fisk came 2 days later. He did not offer to buy the parcel. He said, Meridian would like to discuss a permanent easement arrangement. Claire was sitting at the kitchen table with a notebook open in front of her. She said, go ahead. Fisk said, a lump sum easement payment, $150,000, transferable to heirs, full corridor rights in perpetuity. Claire said, no lump sum, monthly payments, inflation adjusted, transferable to heirs and assigns, starting at $1,400 per month. Fisk said that was not how easement agreements typically worked. Claire said, my client has been waiting 23 years. He's not in a hurry. A long pause. Fisk said, $1,200. Claire said, $1,400. Another pause. Fisk said, we'll need a week. Claire said, you have until Friday. Fisk called Thursday afternoon. He accepted every term. Claire called her father. She said, they took it. Earl said, I know. She said, every term. He said, thank you, Claire. He hung up. He walked to the kitchen. Dottie was at the counter. He said 2 words. They agreed. She did not ask for details. She turned to the stove. She put the kettle on. That was the whole conversation. The signing was at the county clerk's office on April 3rd, 2024. Earl drove himself. He wore the canvas work coat. He signed 4 pages. The clerk notarized each one. He shook no hands in the parking lot. He walked to his truck and sat for a moment with the door open. He pulled the green notebook from the coat pocket. He turned to the last blank page. He wrote, April 3rd, 2024. Easement signed. 400 month. Corridor confirmed. 23 years. He closed the notebook. He put it back in his pocket. He drove home. 3 days later, the Caldwell County Courier ran a brief item on page 6. It mentioned a permanent easement agreement affecting a parcel in the county's northwestern corridor district. It named Meridian Land Partners. It named Earl Mabry. Harlan Pruitt read the item in his office in Columbus. He did not comment. He did not call anyone. He set the paper on the corner of his desk and went back to work. 4 people who had been in that gymnasium in 2001 saw the item. One of them remembered laughing. Not one of them said so out loud. Some men chase land. Earl Mabry let the land wait for the world to need it. Would you have taken the one-time payout or held out for monthly payments for the rest of your life? Drop your answer below. And if you know someone who'd hold out, share this with them.